enjoying women's football when I saw the way these ladies were playing. It was really entertaining this time around at the tournament at the WAFCON. I used not to normally bother watching women's football, but I think it is a really interesting sport. It's not only when men are playing. Okay, so we're saying in the a job must just indicate the inherent requirements. You don't have to say we want somebody who is tall, who is short, when the height of a person is irrelevant in that kind of a thing. That will be discriminating against the shorter people or taller people. And then I think we have dealt with these things yesterday, so we are not going to repeat that. We are not far from finishing. There will be a little bit of other exercise that I'm going to give you later on when we come back, but I can assure you that by around when we come back from lunch, we won't stay long. I just want to make sure that I cover all aspects that I don't want you to be ignorant about. And then we are going to finish earlier today. But now we can go for lunch and then we'll come back at 2 o'clock. Thank you. I hope everybody's back. We are continuing. Note one more thing. On the issue of collective labor law, the bargaining between the employer and the employees, or there's an important aspect there. It is called workplace forum. Workplace forum. It's a forum that is get to be established between the employers and the employees to discuss matters of mutual interest. It's called workers' forums. So can everybody hear me? I just went straight. Hello?
Yes, we can hear you.
Okay, thanks so much. Yes, I was saying workplace forum. It's an important aspect that you need to know. So it's where employers and employees come together to discuss matters at local level, not in the bargaining councils or anywhere, but at local workplace level. That's where this happens. So it's important to note that. It is also important to note the following, that when there's a disciplinary hearing that is going on and the employee happens not to be satisfied with what is going on, and despite the protestations from the side of the employee showing either the unfairness of the process itself or any other thing like what we've been talking about, like the obvious biasness of the chairperson of the disciplinary hearing, or the gross irregularities that is taking place, which need to not be allowed to proceed because it's going to prejudice the rights of the employee going forward, and where you realize that it's going to be very expensive to try and overturn what would have already, the unfairness that would have already taken place at this hearing, where maybe the employee is not being allowed to cross-examine the witnesses as it is his or her right. You have heard that those are the kind of things that should take place if the hearing is said to be fair. There are many other things that one would realize this is a gross misdirection that, if not challenged, it will end up prejudicing the employee. It's better that it be dealt with earlier. What should happen is that you must raise these things with the chairperson, because, as I said, there are people who are having integrity enough especially in their lawyers, to realize that they are not necessarily answerable to somebody who is paying them. In this case, will be the employer, but who are answerable to their own conscience, the law and the constitution, who can conduct disciplinary hearing in a fair manner and be unbiased. But there are instances where you find that there's somebody who forgets all these noble virtues and knowing what the employer wants. We want to get rid of this person. He comes and makes sure that he throws all the book of ethics and etiquette and the knowledge of the law and wants to dismiss the employee at all cost. The employee is also has rights, not obliged just to sit there and be an observer to a plot to try and get rid of him or her. Can't be just a sitting duck. You can challenge these things. And if you are not being heard, you can simply have this thing, the whole process interdicted. You can approach the court, a labor court, to have the matter, to have the disciplinary hearing interdicted. In other words, you can say, no, this disciplinary hearing is not going to result in any fairness because of the following grounds. By the time I complain about this thing after would have been dismissed, because the chairperson, for example, is bent on doing exactly that, and I know the chairperson, maybe it's a friend or my boss or bosses, or I know they've already paid in some money in advance, or I know there's been a leak regarding the information that there was a meeting specifically with the chairperson to brief him about my case and as to what he's supposed to do. And I see these things unfolding right in front of my eyes. Then you can approach the labor court and apply for an interdict against the continuation of the disciplinary hearing. And we can even say against specifically this person that there should be an independent person to be appointed. Yes, a disciplinary hearing can be interdicted. Case of Boysen versus Minister of Safety and Security in 2011, the Labour Appeal Court confirmed this. Yes. So this was also important that we should know. Is there any question in this regard? Is it clear? You can interdict a disciplinary hearing if you have grounds to do so. Are we still all here? Is Boy here?
Boy is here, sir.
Is Boy hearing me?
Yes, sir.
Understanding me?
Yes, I do understand you, sir.
Okay. I just want us to be able to talk to each other. As I told you, I'm not going to keep you up to 4 o'clock. But I want us to not just chase time. I want us to understand each other. Right. It's because we have been talking about disciplinary hearing and stuff. And there are certain crucial issues that I feel that we can't just finish without dealing with them. Okay. Another thing I wanted you to understand is this, that the purpose of the Labor Relations Act 66 of 1995 was set to give effect to the Section 27 of the Constitution, which deals with right labor to fair labor practice. In other words, labor law must respect the Bill of Rights I've already indicated to you, and they've already dealt with a few of those rights. Some of those rights may not necessarily be religious or whatever. Is there any right contravened, if any, in this regard? Maybe where somebody is working for University of Northwest, and all of a sudden they are told that if you do not vaccinate, you must not come into campus to work. And if that person says, it means I won't be able to come to work because I don't believe that that must be forced on me. It's my right whether I want to do it or not. Will there be any fairness on the part of either? Remember, the Labor Relations Act is there to give effect to and to respect the Bill of Rights. Can I hear somebody saying something regarding that? I'll always rush to Charmaine to help if there's nobody. Is Charmaine here?
Yes, sir, I'm here.
What is your comment on this?
Sir, I think this is a debate that will be continuing on to be discussed, because on the one hand, you have your rights that's given in the Constitution, your right to decide on your health and your body. But on the other side, we must look at the right of the general population. And I think that is why the state made this decision to compel us to vaccinate to protect the larger population against COVID.
Okay, can I hear somebody else? Anyone who agrees with Charmaine or maybe has got issues a bit? Can we hear that? You're both lecturers at the University of Northwest. And then, yes, the one, it's fine with what they're saying. The other one doesn't have it's not fine. Does the one who is not fine have any recourse in terms of the Constitution and the Labor Relations Act? Guys. Can be Charmaine alone. Yes.
The one that you are asking if he has recourse, can you just quickly say, is one of them vaccinated and the other one not?
Yeah, the other one doesn't have any issues. He says, okay, I'll do it. But the other one says, no, I'm not interested in that.
So now he's not allowed to have the job.
He's not allowed. He's already having the job, by the way. It's only that now they're saying he must go and vaccinate before he can come to work. He has been going to...
So my opinion on this is that the way that South Africa handled it was actually quite nice, because we have our Section 36, which is the limitation to our rights. And basically, both rights, the right to, freedom of your body was protected, as well as the right to life of other people was protected, because we said that, if you don't want to go and get the vaccine, just present a negative test. That was the perfect in-between middle ground limitation of both rights. So in this instance, I think it won't be a debate for the rest of our lives, because there is only one way we can deal with the situation, and it is by finding a middle ground between the two, which I think South Africa has done. So I don't think the university can force him to get a vaccine in order to come to work. I just think if he presents a negative test, or at least wears his mask, then it should be fine.
In this case, they are not even saying present a negative result. It's simply saying you bring a certificate that you have vaccinated, not that you must just bring results that shows that you are negative.
But in that instance, then I do think it's unfair, because then there isn't a middle ground of rights. Then we are only protecting the rights of others and not our own.
Anyone who sees it the same way or differently? Let me hear from Leon. Yes, who's saying? Who's speaking?
It's Mukwena Tebo.
Tebo, yes, Mukwena.
Yes, yes. I would like to. I would just like to say, I think it's fair to not allow such a person in the university's premises, because we have to look at if this person should be infected, how many people are at risk of also getting the same infection. And even if he was to produce the negative test certificate, but that does not give us the assurance that he is negative, because there's a chance that he might have gotten infected while leaving the doctor's place. And the other thing also we have to look at is the rights of others, especially the right to life. As much as we have rights, we know that they are limited. Yes, he has a right to bodily integrity and so on, but that does not, it does not eliminate the risk of many people getting infected because of one person.
Okay, Teboka, you have spoken about the limitation of rights, Section 36.
Yes,
how do people's rights get to be limited in terms of the law? In terms of Section 36, what does it say? How do you limit somebody's rights?
I'm still thinking about it, sir.
Does somebody know what subsection 36 says? It's somebody having a constitution next to them. Look at Section 36. Or does somebody know it by heart, what Section 36 says in terms of limitation of rights?
So it says that the rights may be limited only in terms of the general law applications.
What does that mean?
The law that is limiting the right must be a law that is applying generally to everyone's. It must not be targeted at specific people or specific.
Do we have such law? Relating to this specific matter we're talking about. Is there a law like that?
No, we don't have a law like that.
I think that's where the problem lies. Because there must be a law. Do you know the difference between policy and law?
I think a policy, uh, a policy is just how do I say it in simple terms? It's just rules that will recommend the laws.
And who makes laws?
Who makes laws is the parliament, sir.
And who can make policy? Can the Senate of the university, can the Senate of the university make policy?
Yes, I think so, sir. They can make policy to govern the university.
Is that policy equivalent to the law?
No, it is not, sir. It's not equivalent.
Is it supposed to be subject to the law of the country, or it can just be regarded as being equal to the law?
No, it cannot be regarded as being equal to the law.
Okay, all right. Let's leave it at that, unless there's somebody else who want to say something, and proceed. Okay.
So, sir,
Yes.
I just want to hear your opinion or your view on that.
I thought you have already heard me, because I asked the question, who has got what does section 36 say in terms of the limitation of right? And all you guys said, it says there must be a law, and it must be called a law of general application, applying to everybody. And then I asked the question, do we have any law that has been passed to limit rights in this regard? I haven't had anybody saying we've got that right. We've got that law. I asked, this thing of telling this person to say he cannot come to work because unless he is vaccinated, it's obviously a policy that has been taken by the employer. I said, does policy trump the law? You said it cannot trump the law. Does that give you an opinion as to where I stand? Because to me, you can come with a policy and say our policy is like this and this, but the question is that policy being elevated to the position of law so much that it can be allowed to trump and limit people's rights? If it doesn't, then it means it's not constitutional, and therefore it cannot be allowed to stand. You cannot force somebody to do something that is against their rights in terms of the Constitution. That's what I'm saying. Am I clear?
You're clear, sir.
Yeah. So that's why I stand. If you were to know where I stand, everybody has got the right to their opinion, but at the end of the day, let's go to the law and hear what the law says. Okay. Also, in terms of the Labor Relations Act, there are specific categories of workers or employees, if we're to call them that, who are excluded from the ambit of the Labor Relations Act. Yesterday we heard about people who are not allowed to strike, although they are employees, if they are in certain sectors. But there are those who are completely excluded from all the provisions of the Labor Relations Act. Although, who are those? Which categories are those? When you are employed in any of those categories, you can never claim any rights that are in the Labor Relations Act. Which ones are those? If you are working there, you are not regarded as an employee in terms of really being an employee per se. You are there, you are working there. You have got your own statute that will apply to you, but it will not, you are not covered by the Labor Relations Act. Which ones are those categories? Yes, Charmaine.
Sir, the members of the National Defence Force.
Yes. If you are a member of the South African National Defence Force, you cannot be claiming any right under the Labor Relations Act. The Labor Relations Act does not cover the South African Defence Force. If you are there, you must know that you are there to serve the nation, not that they will have to treat you anyhow, but there is a different statute that deals with that category of people. That's why we don't even call them employees. What do we call them? What do we call members of the South African National Defence Force?
Public servants.
No, they are not called public servants. Public servants are those people who are working in other departments of state, those who are working at the Department of Health, the Departments of Social Development, Department of Education, Department of Home Affairs, and all that. Those are public servants. Those who are working for the South African National Defence Force, what are they called? It's a very simple matter. Are they not soldiers?
Essential workers.
No, not even essential workers. They are called soldiers. They are, yes, they cannot strike. They are essential, but they are soldiers. And when you are a soldier, there's what we call military discipline. Do you know they even have their own courts called military courts? There's a military judge, military courts, not that, but that is related to their conduct there at work. They will not just call you because you are a lawyer to go and preside there. You must know military law. Military, it's a different kettle of fish. It's a different world altogether. People who are working for the Defense Force know that they are soldiers. Their rules are very strict, sometimes very harsh, to an extent that even if you are not necessarily in combat, you are employed by the South African Defence Force in your professional capacity. You are subjected to their rules, you are subjected to their laws, and you cannot be claiming certain rights which people who are working for other departments and other private organizations are claiming. When you are there, you are subjecting yourself to a whole different kettle of fish in terms of the kind of organization you find yourself in. Even if you are a lawyer or you are a medical doctor, the medical doctor that is working for the South African Defence Force is not the same as a medical doctor that is working for the Department of Health in terms of how they are to be treated, in terms of their rights and obligations. The one who is working for the Department of Health, they go to work and they put on their clothing and there's and whatever white coat and all that. It ends there. When you are working for the South African National Defence Force, you are first and foremost a soldier. Even if you are not going to be given a gun and go to the border to fight or anything, you are regarded as a soldier. What you do is that even at training, during orientation, before you start working, they'll take you to some training that will be military related. For example, you'll be told that you must exercise. Before you go there, they actually tell you what weight you must weigh. What is the maximum that you can weigh? You must go to the gym. If you are of a certain weight, they won't take you just on that alone, depending on what you'll be doing. Even if you are just a professional and not a soldier as such. That is a South African National Defence Force. You will be taught discipline. If you were to go there and say you want to be maybe their legal advisor, they will tell you in the morning, this is what you do. Even before you start working, or maybe you've started working, but you are still on training or orientation, they will observe whether you make your bed when you wake up, how your bathroom looks, and whether you are able to cook for yourself. And those things are important. They are going to go into your file. You must be able to salute the generals. And yeah, there must be a drill every morning, even when you are not a soldier. So that's why their rights are different from the rights of everybody else. Is there any question in this regard? Whether you are a lawyer or whether you are a doctor, a psychologist, whatever, you have to go through all those things. And above that, you will have a rank assigned to you, just like any other soldier. If at a certain level, they call you a general, you'll be a general who is not necessarily a soldier. And you put on uniform. Hello? Is there anybody who was interested to go and work there? And they pay very well, by the way. They pay very, very well. But these are the things that you must be prepared when you go there. You can't go with a labor relations mind, labor relations law mind. You go there understanding that you are going to serve your nation. Yes, you'll be paid very well, but there's some discipline that will be required of you. And then you must be able to deal with it if you were to survive there. I'm told there was one guy, ironically, he's from Potchefstroom. I forgot his name. He went there. He was a medical doctor, apparently. And then he was surprised why he was being forced to do some of these things. He said, look, in my life at home, was never made to wash plates. I was never made to make my own bed. all these things were done for me. I cannot come here and be told to do these things for the first time in my life when I'm this grown up. And he put up a resignation immediately and he left. Yes. So, because you know very well when you go there that the labor relations does not apply, then it's reasonable. You cannot go and complain anyway. You know, you knew where you were going, you know. Yes. Tandis was saying, the problem is not the money. I don't want to do that obstacle course or soldier training. I'm good outside defense. Yeah. Yes, it's good that you know before you go there. So nobody should entice you with money and say, look, let's come and work here. There's good money if you know that you won't stand some of these things. That's just how it is. Okay. Another, apart from South African Defence Force, who else is not included in the Labor Relations Act? Who else? Boy, is Boy here?
Boy is here, sir. I think members of SAPS are not also included.
You mean the police?
Yes.
No, it's actually members of the State Security Agency. You know the spooks. Those people that you know may not know. Yes, Charmaine, you wanted to say something? Charmaine?
No, sorry, I didn't. My hand was still up, sorry.
Oh, no, it's fine. Yes, members of the State Security Agency. Those people who must look after us in terms of checking what threat is there against the country, who know what we don't know, who has got all information about almost everybody without us knowing who they are. Security agency members. Even there, it doesn't matter which section you find yourself in. Labor Relations Act doesn't work. You must forget about it when you get there, if you decide to go there. And you must know that there are certain disciplines that you must comply with. Like they even tell you who to mix with. You can't just have any friend. They can tell you when you are working here, you must be careful of Tebo. Don't ask us many questions. We are telling you, if you continue to have Tebo as your friend, we'll deal with you. So there's no such freedom like when you are an ordinary employee somewhere. Once you get into those institutions, you must know what you're getting yourself into. There are certain things that they'll tell you, they should remain with you for the rest of your life. It's a secret. It's a national secret that must never be shared with anybody. If you share it with somebody else, that will constitute misconduct. So it is very important that you know these things. One day you might be having a client that comes from there. If you don't know, you'll be giving them wrong advice. You know, so they need to know who they are and what is it that is expected of them, and they must comply and not try to waste their time and saying they are going to go to court to challenge any of these things. There was one friend, or former colleague, let me say, who used to work at one company. I don't know what may happen to him. I met him the other day saying he's now working for the the State Security Agency. That person could not even stand with me for 15 minutes. He was looking all around whether there was anybody looking at him. And he said, yo, I'm working at this place. I'm an accountant, but there are even certain accounts that I'm not allowed to audit. He's an auditor, apparently, yes. There are certain accounts that is not supposed to audit. There are certain monies and budgets that are used for underground activities that are not supposed to be known by every Tom, Dick, and Harry. So this is how things are in some of those things, organizations. And it's important that we get to know about them, and so that we may know how to distinguish between ordinary employee and some of those who are not covered by the Labor Relations Act. Lastly, I want us to work on this one. And once we work very well, nicely on this, we are going to be done for today. The content of a contract of employment. Who knows what a contract of employment should look like? We have been talking all this time about the formation of the contract, but if it were to be in writing, because the others are not very clear what they will contain, some are very short, some is just by conduct, as we said, or just verbal, but there are certain elements that are important that they should go into a contract of employment. If I were to ask you, what would be those things that must be included in the contract of employment? If we are to say we are entering into an employment contract, you and I, what would be the things that should be included in that contract? Tandiswa?
The name of the employer, or let me just say the details of the employer and the particulars of the employee, the kind of job that is offered, and the date to assume duty, and also the amount. Yes, the remuneration.
The names, the particulars, obviously, the names, Tandiswa Muleleki, ne?
Yes.
Am I right? Tandiswa Muleleki, of such and such an address, a female, age. You must tell me if some of this information will not be fair to include. Female, that must be included, no? The gender.
Yes, it must be included.
Okay. The age or date of birth must be included.
Yes.
And the ID number must be included. Obviously the address and the phone number and stuff like that. Marital status? Should it be included or not?
It should be.
Why?
In instances where there's packages at work, or yes, I think packages at work, they'll need details also of your spouse. And yeah, I think in terms of maybe if you're married also in community of property, is very important to also give the details of your spouse around the.
Okay, somebody else? Somebody else? Thanks very much for that information. It may not be the status of your marriage, but to know that you are married is important because it has got a bearing on the issue of, tax purposes, pension purposes, and just to know. So who is the closest person to contact and all that. That is also important. What else? Ryan?
You also got to include the duration of the contract, like when it starts, when it's going to end, if there's a probation period, if the person will become a permanent staff member afterwards. I'm not sure if it was said previously, but the remuneration and duties or hours of work and, overtime, leave of absence and how to be terminated, etc.
Yes, we'll have to know what. Yes, it's a contract of employment, but what are you hiring me for? What is the job title? When is the commencement of this contract? When does it end? And duties, what will I be doing exactly? You see? And where will I be performing these duties? You're a big company, you're all over the country, and I must know in which office will I be placed, Pretoria or Cape Town? That is very important. The duties exactly. To whom do I report? Be reporting to manager, human, public relations, whatever the case may be. When do I assume my duties? Hours of work. Can't just leave it and say, okay, you are employed, you must come to work. You must tell me exactly what time must I report. Also, it must be indicated if I'm going to be expected to be on probation first. And if I'm going to be on probation, for how long is this probation going to be? Probation, remember, it's a trial period. It means you are not necessarily permanently employed until you finish your probation. Even if they say you are on a permanent contract of employment, you must always make sure that you work smart and faithfully until your probation, so that it can be known that you are now permanently employed. So probation is very important to be included. And also to indicate whether this is a fixed term contract or whether it is a permanent appointment. And also how much. Can't just work without knowing how much I'm going to be paid. It must be clear whether there are going to be deductions out of that or not, whether there are going to be other benefits included or not, whether there's going to be pension or medical aid. It must be clear whether you are going to be allowed to get your own medical aid, and then they'll just give you the money for medical aid, and then you'll pay it over. It must be clear. Whether you're going to earn per month or per week, it must be clear. Yes. Also, there must be things like what is going to happen regarding leave. How much leave are you going to be entitled to? What kind of leave? We have spoken about the different types of leave. Every company will have the right to, I mean, those are stage 3, they must provide for them. And then but the nitty-gritties will definitely have to differ from company to company. Yes, and also another thing is, what about notice? If you want to resign, you'll give a notice of how many weeks or how many days. That is very important. And there are other, specific clauses that may not necessarily apply generally. Like when it comes to the issue of privacy, might have to be indicated what privacy will be important in this company, because companies are different. If you are a candidate attorney, for example, they may tell you that you must keep the privacy of their clients and all that. There might be clauses like restraint of trade. After you finish your articles here, you must not work anywhere within a radius of 500 kilometers from your current employer's office, and all that. So these are the things that are important. But also, what is important is that you will need to know the disciplinary code of that company that is hiring you. Disciplinary code, it's a booklet or a document which will tell you, in this company, how do we conduct the issue of discipline? How do we conduct discipline? What are the things that must be done in terms of our disciplinary code? How are you expected to conduct yourself? And what are the possible charges that may ensue as a result of your conduct? And how are we going to deal with those things? Who will communicate with you about that? And how are you going to represent yourself? Are you going to be allowed to bring a lawyer or a colleague? How long will it take? And what are the possible sanctions that can result once you are found guilty? There will be such things as dismissals, final written warning, informal warning, that's verbal warning, suspension without pay, demotion. Those kind of things need to be known in advance. They must be inside the contract itself before the employee signs the contract and begins to start working. So yes, such things as the disciplinary record, what will happen if you've been found guilty, this will go into your file, but it can't remain in the file forever. After how long will it be expunged, and all those kind of things. So it's important to have these things and to know them, whether some offenses are regarded as being so serious that just the first offense you can be dismissed or not, so that you know this in advance, so that you know this, I shouldn't play next to this. Sexual harassment, this is regarded as serious. I can lose my job just for flirting with this lady. If she doesn't like it, she can report me and I can be in trouble. Then you know what kind of offense will attract a written warning and all that. And you know after how many days can you appeal if you've been found guilty. Must be recorded, all these things. Yes, so this must all go into contract of employment. A contract of employment is a very, very important document. You don't just get excited and say, I've got a job. You must read even the small print, so that you mustn't be caught by surprise in any manner. So you should be able to, if you have really grasped the LDR, you must be able to write or draft a contract of employment. It must indicate the purpose, you know, and all those kind of things. So also of importance, it must be indicated during the disciplinary hearing whether it will be recorded, and the venue, and all those kind of things. And then your rights must also be indicated. So yeah, I think basically these are the things that must be included, and these are the things that we need to know. The issue of confidentiality, taking into consideration the interests of the employer, and all that. It's important to have this kind of things. If there's an issue of the union, you must be told there are unions in this, you have the right to belong to any one of them. These are the conditions, and this is how much is going to be deducted as subscription amount to be paid over to the unions and all that. So yeah, basically that is it. You need to know these things. Can you be able to draft an employment contract if somebody were to ask you to draft one for them? I think, can you be able to do that? Let me do this. Yes, Can you be able to do that, Charmaine?
Yes, sir, we will be able with all the information that you gave us. Thank you so much.
Right. Do you have any questions whatsoever up to now? For clarity, because that is important. Not only on this aspect, but generally on everything that we have been dealing with since yesterday. Is there anything that you feel you need to know? Is there anything that came up but was not completely clear? Are you sure that I can be proud of you one day when I find that you are an expert in labor dispute resolution and there's nothing that is lacking with you, and that you are able to stand your ground in any situation against anybody? Ryan, can I be proud?
Yeah, I hope so, sir. I hope so.
Ladies and gentlemen, thank you very much. As I indicated to you that I dealt with a lot of these things yesterday, and today I wanted to make sure that there's nothing that is left behind. I'm going to release you earlier. It is my pleasure right now at this moment because I can see you have grasped everything and you are clear that I'll say thank you, and I wish you all the best in your future endeavors, in your careers, in your exams. Thank you so much.
Thank you, sir. Have a good afternoon.
Thank you so much. Same to you.
Thank you, Council.
Thank you.